Thanks everybody for joining us today. Just our standard quick disclaimer, this presentation is for educational purposes only. It's not legal advice and it doesn't create an attorney-client relationship on its own. If you're already one of our clients and you've got specific questions for us, you can send that in through our portal, as Dan noted. If you'd like to become a client, you will have some information at the end for you to check out. And today, even though we're talking about frequently asked questions, we're just really providing an overview. The information is kind of a compilation of some of the questions we see. They're maybe not exactly specific to a certain situation, but we're giving you an overview of the types of questions we see on some subjects that turn up pretty often. And we'll try to keep things moving today so that you can get on with your day as we go through these frequently asked questions and provide some background on answers for those issues.
All right, question number one. We have an employee whose certification form allows for intermittent FMLA use. What are the rules for intermittent FMLA?
That's a question that we're seeing a lot more of recently. Just to give you an overview, we should probably start with FMLA itself. So that's the Family and Medical Leave Act. That's a federal law, and it allows an employee to take a certain amount of job protected leave for their own serious health condition, a family member's serious health condition, birth or care of a child, and certain types of military leave. Which employers are covered by FMLA? Well, it applies to private employers with 50 or more employees, and they also must have those employees working for at least 20 work weeks in the current or preceding calendar year. Which employees are covered under FMLA? That's another question that sometimes somebody comes in and they start their question with, hey, we have an FMLA issue, but we need to get some background first on our side of things to make sure FMLA actually applies. Is your company big enough? Has the employee met the requirements? So you don't always necessarily presume that somebody's covered by FMLA, but if you're not sure, we can certainly help you out with that. So for an employee, they're covered if they work for a covered employer, as we just discussed, and they've been employed for at least 12 months with at least 1,250 hours of service in the preceding 12 months before using FMLA, and they work at a location with 50 or more employees within a 75-mile radius. So again, the foundational issue of whether FMLA even applies sometimes needs to be looked at if your company is close to 50 employees or your employee has worked a certain number of hours. Those are things that we would want to look at on the front side before getting into FMLA. And so what is intermittent FMLA? So that is also often paired with reduced schedule FMLA. They're sort of in the same part of the written law that covers FMLA. It's intermittent and then reduced schedule. So those are ways for a covered employee to use FMLA time off that's not one continuous block of time. A lot of people think, hey, they're on FMLA, they're going to be gone for 4 weeks. Well, it's not always that. FMLA also covers intermittent leave and it also covers reduced schedule leave. So intermittent would mean taking leave in separate, non-consecutive blocks of time for a single qualifying reason. That could be to attend like physical therapy appointments, something like that. Reduced schedule leave means that the usual number of hours worked per workday by an employee is reduced for FMLA purposes. But focusing in this question on intermittent FMLA leave, so what rules does an employee have to follow if they're using intermittent FMLA? Well, they have to, number one, provide notice to you as the employer. They've got to let you know that they need intermittent leave, not a continuous block of time. And they also need to let you know the estimated frequency and the duration of those absences for intermittent leave. An employee who's using intermittent leave also has to provide medical certification. They've got to give you, the employer, some kind of certification document from their healthcare provider that supports their need for intermittent FMLA leave. Again, not a continuous block of time leave. An employee also needs to schedule their intermittent FMLA use responsibly. They've got to make reasonable efforts under the FMLA law itself to schedule appointments or treatments during less busy times of your workday or outside of your company's work hours to avoid unduly disrupting your operations. So the employees have some responsibilities they need to follow. Now, what about employers when they're dealing with intermittent FMLA? You've got to, as an employer, use the smallest increment of time in your timekeeping system with FMLA use by an employee. It can't be greater than 1 hour. So if your timekeeping system is a 1/10 of an hour, a quarter hour, half hour, up to 1 hour, that's what you have to use for intermittent FMLA use by an employee when you're measuring that time. Also, FMLA provides 12 weeks of time off for an employee. When you're using intermittent FMLA leave, that 12 weeks has to be converted to hours. So if you've got an employee who works 40 hours a week, their intermittent FMLA leave time would be 480 hours. So remember, keep it in hours. Some real good best practices to consider as an employer: if you've got an employee who's using intermittent FMLA, keep very good records of leave use, track those hours, the hours exactly. You can also hold your employees to your notification policies. If an employee is going to use intermittent FMLA, they should let you, as the employer, know their need for leave, why they're taking it, and the anticipated time they're going to need off for that intermittent leave. Those are just some kind of good best practices to keep you on track with intermittent FMLA.
Question number 2. An employee has requested pregnancy accommodation. Are the PWFA rules more permissive than the ADA reasonable accommodation requirements?
So we are receiving a lot more questions on the Pregnant Workers Fairness Act now, or PWFA. And we're going to talk about how there is some similarity between accommodation with the Pregnant Workers Fairness Act and the ADA, and how there are also pretty significant differences for employers to consider. So just to kind of give an overview on the Pregnant Workers Fairness Act, or PWFA, the law came into effect in 2024, and it requires covered employers to provide reasonable accommodations to employees with known limitations that are related to their pregnancy, to childbirth, or related medical conditions, unless providing the accommodation would create an undue hardship for the employer. Under the PWFA, these accommodations include things like modified work schedules, additional breaks, or temporary changes to job duties. The whole purpose behind the law is to make sure that pregnant workers can continue to perform their job. Which employers are covered by the PWFA? Well, it applies to private employers with 15 or more employees. And employees are protected under the PWFA if they have known limitations, which means a limitation would mean a physical or mental condition related to, affected by, or arising out of pregnancy, childbirth, or related medical conditions. Now, employers who are already used to dealing with the ADA reasonable accommodation process, again, you may hear some terms and see some similarities, but there are some significant differences. But to give you a little background as a refresher on the ADA, that's also a big federal law, the Americans with Disabilities Act. It also applies to private employers with 15 or more employees, like the Pregnant Workers Fairness Act. Under the ADA, employers are prohibited from discriminating against qualified individuals with disabilities, and the ADA has obligations to provide reasonable accommodations for applicants and employees with disabilities. An employer needs to engage in an interactive process to determine accommodations under the ADA, and an employer under the ADA has to maintain confidentiality of medical information. With the ADA, as we sort of just discussed with the PWFA, an accommodation does not need to be provided if it results in undue hardship to an employer. However, keep in mind, if you are looking at using an undue hardship argument under the ADA, that's a high bar for an employer to clear, and that generally means significant difficulty or expense to the business. It can't be mere inconvenience. It has to be actually documented significant, and it has to be expensive in order to claim undue hardship. So to answer the question posed, yes, the PWFA is more permissive for employees than the ADA. So how is it more permissive? In other words, a person has limitations that are related to their their pregnancy, or their childbirth, how is the PWFA more helpful for employees than the ADA? There's more potential accommodations under the PWFA is one thing that employers need to look at. Both the ADA and the PWFA require reasonable accommodation, but the ADA does not require a suspension of an essential job function as a reasonable accommodation. Again, with the ADA, somebody wants an essential job function suspended. Under the ADA, you do not have to provide that as a reasonable accommodation. The PWFA, however, and very significantly, does allow for temporary suspension of essential job functions as an accommodation under the PWFA. And temporary under the PWFA is up to 40 weeks. So you can have an essential job function removed as a pregnancy accommodation under the PWFA. The law also explicitly lists accommodations in the body of the law, which the ADA does not. So in the PWFA, some specifically listed accommodations are carrying water, taking additional restroom breaks, modifying a position sitting or standing requirements. And again, that temporary suspension of essential functions is part of it. There's also, for an employee that is looking for an accommodation under the PWFA, there are fewer documentation requirements that an employee needs to meet under the PWFA. In contrast, the ADA, an employer can require supporting documentation from the employee to determine if a disability and a need for accommodation exists. So the ADA, better for employers with requiring documentation. PWFA, an employer can't require documentation if the need for the accommodation is obvious. You know, for example, if the employee is visibly pregnant and they come to you and say, hey, I need more restroom breaks, you're basically going to have to provide that under the PWFA and without documentation, because you'll be able to see that the employee is visibly pregnant. Another challenge that employers need to deal with the PWFA is it's a newer law. As we mentioned, it just became effective last year. So employers are still getting used to it, figuring it out. And we have had a lot of questions, I would say, in the last several months from employers asking us, hey, what do we do with this? What do we do with this law? Our employee is pregnant, she came to us, what do we do? So that's an area to navigate. So as an employer, some things you want to consider with the PWFA and making sure that you stay within the laws, you want to establish a clear accommodation process. So just have in mind, if you've got workers that are pregnant or going to have a kid or have had a child, that you've got to work on accommodating them under that law. You want to train your managers and your human resources department on the requirements of the PWFA. If an employee comes to you and says that they need an accommodation related to pregnancy or childbirth, you've got to engage in the interactive process under the PWFA, just like you would under the ADA, to see what reasonable accommodation the employee might need. Again, some potential accommodations can include schedule changes, more frequent breaks, equipment modifications, and also I'm going to reinforce that you can't rule out temporary suspension of a job's essential function to accommodate a worker under the PWFA. You've got to also make sure that if a pregnant worker or a worker who has given birth requests an accommodation, you work on that promptly. You don't let it sit. Document all conversations on the topic. Document any attempted accommodations, and make sure that you're not requesting unnecessary medical documentation from the employee. Again, if you can see visibly or have knowledge that the person is pregnant or has given birth, you cannot ask for documentation at that point if they're looking for accommodations related to those conditions under the PWFA. And also make sure you're consistent with your treatment of all similarly situated employees.
Question number 3. I need some new workers for a specific project. Do I have to hire them as employees?
That is a question that we're also seeing turn up more and more with us, where people are concerned about some of the risk factors we're going to talk about here, and they're looking for ways to address those and make sure they're still getting their work done for their business. So workers, when they're hired, they're generally brought on as either employees or as independent contractors. And in looking at that classification of a worker as either an employee or an independent contractor, it comes up a lot, and it's always worth revisiting to make sure that your company is staying on track and not running afoul of all the rules in that area. So an employee is generally somebody that is paid wages and receives company sponsored benefits. They're subject to very significant oversight. They're controlled by their employer. They are employed for a continuous period of time, and they do whatever tasks the employer requires of them. And with an employee, the company generally pays their wages, their Social Security and income and Medicare taxes through withholding. In other words, the employee is not required to themselves pay all those taxes into the government. An employee is also generally economically dependent on an employer, and they are covered by a number of employment laws. So if you're an employee, you're working for a longer period of time, you're controlled by the employer, and you've got a lot of protection under the law. Another common type of worker out there that's not an employee is an independent contractor. And those individuals, generally speaking, are people that offer their services to the public for a fee. They don't work for just one employer. They offer their services broadly to all kinds of different entities out there. And an independent contractor is not economically dependent on a single company. They're not attached to one company all the time and make all their money from one company. That's not what an independent contractor does. They work with many different organizations. They charge a fee for their services. They are only engaged for a specific period of time to do a specific project. They maintain control over their method and manner of work. They have independent contractors have economic independence. They are responsible for paying their own taxes, and they are not covered by employment laws that cover employees. So with the question regarding the specific project, if you're looking to bring some people on to help you with that, they don't necessarily have to be hired as employees of your company. As an employer, you have some options with how you're going to proceed with hiring somebody. You certainly could hire somebody as an employee, even for a short period of time. That is probably the lowest area of risk. However, if all the requirements are met, you could potentially hire independent contractors. But again, there's risk in making sure that the person truly is an independent contractor under the law, and you're not hiring an employee and just calling them an independent contractor in order to avoid certain responsibilities that employers have for employees. So if you're looking at hiring independent contractors, there are some federal tests to follow as to whether the person is actually an independent contractor or are they really an employee. The federal tests to show that someone's an independent contractor generally focus on the degree of control the employer has over the worker. That's the overriding factor. There's several different federal tests, so that's something to look at if you're thinking about hiring someone as an independent contractor. Again, you want to make sure they actually legally are an independent contractor so that your company doesn't get into trouble with a misclassification claim. There's also a lot of state laws that can be in play. Each state has laws regarding worker status, whether they're an employer or an employee. Those laws are in place in the workers' compensation context, sometimes in the tax context and the unemployment insurance context. So these states can have many, many laws as well. And you want to make sure that you're following not just the federal law when you classify a worker, but also the applicable state law where your worker will be working. So an example, and kind of an extreme example, but I want to tell you about a state law that is a test that's used to determine whether somebody is an employee or an independent contractor, and that is the so-called ABC test that's used in California. So the ABC test uses three factors: factor A, factor B, factor C, to see if someone is an employee or if they're an independent contractor. So factor A is the worker is free from control and direction of the hiring entity in connection with the performance of the work. Factor B is the worker performs the work that is outside the usual course of the hiring entity's business. We'll talk more about that in a minute. And factor C is the worker is engaged in an independently established business of their own for performing the work. So in an ABC test state like California, an example of an independent contractor would be a carpenter that's hired to remodel the break room of a software company. So under factor A, the software company doesn't tell the carpenter how to do his carpentry work. He's coming in just to do his thing, doing the remodel work. Factor B, the carpentry work by the carpenter is outside the normal scope of business of a software company. A software company doesn't perform carpentry work. So a carpenter coming in to do a remodel project for them, that meets factor B in California. And then factor C, a carpenter would have his own independent carpenter business that would not be a division of a software company. A software company would not have a carpentry division. So therefore, in this example, again, of a carpenter hired in California to remodel a software company's break room, you could classify that person as an independent contractor because factor A, factor B, and factor C would all be met. Another area to be concerned with, or to consider, I should say, when you're looking for workers for a specific project is potentially using a staffing agency to cover your specific project labor needed. Staffing firms are a good option to supply workers for specific projects. They would not be your employees. They would be employees of the staffing agency. There are several different types of staffing agencies that are out there. You can have professional services, healthcare, light industrial, real estate. So that's another potential option that an employer could consider for a specific project if they don't want to bring somebody on as an employee, or they're concerned about whether or not they could legally use somebody as an independent contractor.
Question number 4. My employee needs to travel out of state for work. Is that time compensable?
Travel time is a big question that we see recurring in lots of different forms, and I'm going to go through some of those momentarily here, but we see it from everything involving commuting to different driving to different work sites during the day to having to travel for the employer out of town. There's different rules to look at with that. Again, generally a best practice is to start with what the federal rules say and then drill down to the state rules where your workers are located to get into it. But it's frustrating, but travel time, like other issues we handle, a lot of times the answer is it depends. So here it depends on whether or not certain criteria are met as to whether the travel time would be compensable. So we're going to start with the federal law, the Federal Fair Labor Standards Act. That is a very broad and very old federal law that covers minimum wage under the federal rules, overtime pay for hours worked over 40 in a work week, child labor, employer record keeping, and whether a worker is classified as exempt or non-exempt. So the FLSA applies to most private sector employment, as well as a lot of government employment, but basically private sector employers are generally covered by the FLSA. So the FLSA does address travel time, and there's some certain rules we want to go over because they are important. And if your state doesn't have a specific state statute that talks about travel time, then you will default to these federal rules. So they're definitely worth going over. So the FLSA looks at several different types of travel when they're considering whether that time is compensable for an employee. So the first one is home to work travel. An employee who travels from home before the regular workday and returns to his or her home at the end of the workday is engaged in ordinary home to work travel, also known as commuting. So that time under the FLSA is not work time. It's not compensable when an employee is just doing a regular commute. Now, somebody is going from home to work on a special one-day assignment in another city. Now, this is kind of odd. Some of these classifications are strange, but this is just how the law is written. And again, if you don't have a specific statute in your state addressing travel time, then you're going to have to default to these federal rules. So that's why we kind of want to touch on them briefly here. So home to work on a special one-day assignment in another city. In that case, the time spent traveling to and returning from the other city is work time. However, it is not work time if it covers the employee's regular commuting time. In other words, an employee's regular commute time, say it's 20 minutes to and from, that would not count under the home to work on a special 1-day assignment. That would not be, your commuting time would not be compensable. If you have questions on any of this stuff, just as a side note, let us know, send us a ticket through the portal. But I want to make sure I'm covering these factors because, again, this is a question we're seeing very frequently. Travel that's all in a day's work, that basically covers time spent by an employee as travel as part of their principal activity. If they're going from job site to job site during a day, that's compensable time. That is not their commute. They are at the direction of the employer. They're going from site to site. That's compensable time. Travel away from a home community. Under the federal rules, it's a little strange, but it's worth sort of going over again in case you don't have a specific travel time rule in your state. Travel time is compensable during the employee's regular workday. So if your employee works from 8 a.m. to 5 p.m., any travel time during that time frame is going to be compensable. And that also applies if the employee is traveling on the weekend, even if they maybe don't work on a Saturday, but their normal workday is, say, 8 to 5. Anytime somebody is traveling during the hours of 8 to 5 on a Saturday would be compensable work time with this rule under federal law. However, and there's always got to be a however, if somebody is commuting and it's outside of their regular work time, again, to travel away from their home community, and they are a passenger and it's outside of their regular work time, then that time is not compensable. Some of these rules seem a little crazy, they're a little complex, but again, that's when it's good when you can reach out to us and ask us a question on that. To follow up on what I had mentioned earlier, you also want to consider the state rules. You want to start with the federal rules. They're the most broad, they apply to a lot of employers. However, your state might have a rule that's more favorable to an employee regarding something like travel time. And if there is a more favorable rule, that's going to take the place of the federal rule, the more favorable state rule for the employee. Again, we're going to go back to California, not to pick on them, but they are a state that has a lot of rules that favor employees over employers, and they are sort of seen as a bellwether of passing laws that then other states try to pass. So with travel time in California, they are more strict than the federal rules under the FLSA. California, for example, does count passenger time as work travel. Anytime basically that you are spending traveling at the direction of your employer, if you're in California, is going to be compensable time. It doesn't matter if it's outside your regular work hours under the federal rule where you don't pay. Under California law, you would pay if it's outside the regular work hours because you're considered to be under the control of the employer.
Question number 5. What's going on right now with immigration rules and the temporary protected status for workers from certain countries?
We are getting a lot of questions regarding immigration. We've done a webinar, in fact, on it that you can look up, addressing some of the concerns that employers had earlier this year when we had a new federal administration come in. So the last federal administration offered temporary protected status, or TPS, work eligibility to people who arrived from certain countries. So TPS is a program that allows the U.S. Secretary of Homeland Security to designate a foreign country for temporary protection due to war, natural disasters, or other extraordinary conditions that make it unsafe for its citizens to return home. So eligible people from designated countries who are already in the U.S. can apply for TPS. And that gives them, if it's approved, it gives them temporary permission to live and work legally in the US and then protects them from deportation. So TPS is a temporary status, as its name implies, and does not necessarily lead to a permanent immigration status or citizenship. But while TPS is in play, somebody can live and work legally in the US. So with a new federal administration coming in earlier this year, the TPS program from the previous administration was looked at and addressed in terms of scaling back a lot of what was offered before. The current administration is cracking down on illegal immigration generally, but is also looking to cancel TPS and other parole programs that provided work eligibility. And a parole program, if you ever hear that term, it's temporary status granted on a case-by-case basis to permit individuals to enter or remain in the U.S. for urgent humanitarian reasons. So it kind of goes hand in hand. A parole can go hand in hand with TPS. Both of those are statuses that would allow somebody to work, and both of those are now being rolled back. So we're getting a lot of questions from employers. What do we do? This is actually a big concern for employers that we work with as our clients because of all the ramped up enforcement at the federal level right now. So what's happening with TPS is that litigation regarding what was put in place by the last administration is currently ongoing. So litigation is happening. A very well-known hot button in the TPS program is the so-called CHNV group. That's an acronym for TPS for citizens of Cuba, Haiti, Nicaragua, and Venezuela. The current administration has canceled TPS for those individuals, again, Cuba, Haiti, Nicaragua, and Venezuela. But there's ongoing litigation, and there's also uncertainty because of that litigation around the termination of TPS for those individuals. Have they been actually terminated from the program? It's a back and forth battle right now. Things are happening at the federal district court level, the federal appellate court level, and also the U.S. Supreme Court level regarding TPS and specific programs. For example, out of the CHNV group, Haiti, there's now a court-ordered automatic extension of the employment authorization for TPS Haiti recipients. Right now, certain people from Haiti with an employment authorization document that they obtained under a TPS program, those are now valid. They are no longer canceled. They are now valid through February 3rd of 2026. Venezuelan workers also received a recent court victory extending their status. However, with both of those groups, the Haiti group and the Venezuela group, with their TPS, the decisions that are in their favor are being actively appealed. What does all this mean for you as an employer? There's a tug of war going on. There's a back and forth through the courts. It's uncertain. So what does this mean for you as an employer? What I would say to start with is be very careful with your hiring paperwork. You want to train your hiring staff on which documents are acceptable and how to spot fake documents, for example. You also want to be very careful in noting document expiration dates. If somebody has a document that's expiring, you're going to need to recertify them when needed. So if a worker who is working for you now presented an EAD, an employment authorization document, and that document is expiring or it's been canceled federally, don't automatically fire the worker necessarily. First, you probably should give them a chance to recertify their work eligibility. What that means is if somebody had an EAD, and that's, if you're familiar with the Form I-9, that's a List A document. If their List A document is no longer valid, either it's expired or it's been canceled, they have to have a chance to recertify their work authorization with you. So then they can either present one document from List A on the I-9 form, or a combination of one document from List B with one document from List C. And all that information is noted on the I-9 form itself and also in the I-9 instructions. Importantly, to avoid liability, if you're a business that uses subcontractors, you should consider having in your agreement with your subcontractors, the subcontractor should certify compliance with all immigration laws and confirm valid work authorization for all workers that they're supplying to your work sites. The subcontractor should agree to cooperate with investigations and provide documentation if needed. The subcontractor ideally should have indemnification obligations for your company against problems that they generate through immigration violations. And in your agreement, you should consider being able to terminate the subcontractor if they don't comply with the immigration requirements in your contract. Another area that an employer can do to help reduce their risk is consider using E-Verify. So what is E-Verify? It's a free internet-based system operated by the U.S. Department of Homeland Security, DHS, and the Social Security Administration, SSA, that helps employers electronically verify the employment eligibility of their new hires by comparing information on the Form I-9 with government records. So with E-Verify, you can get automated link to government databases to confirm an employee is authorized to work in the U.S. If you're an employer that uses E-Verify, you know this helps you maintain a legal workforce and protects jobs being taken by people who are not authorized to work in the U.S. If you're an E-Verify user and all of your workers are covered under E-Verify, your risk of an issue with immigration is going to be reduced significantly. Another factor that we get questions on and is an idea to adopt as a best practice if you're concerned in this area is be prepared if you've got a visit from Immigration and Customs Enforcement, ICE. If you've got a visit to the work site, you want to have a plan ahead of time of how your company is going to respond. You should designate a point person. So that would be one individual to handle the interaction with ICE. Don't have a bunch of people, have one person who's designated. If you're presented with a warrant from ICE officials, you want to verify the warrant. You want to make sure it's valid. Take a look at it. Have your point person do that for you. You do not want to interfere with ICE, and you do not want to provide false information to ICE. Either of those actions are crimes. Those crimes are being actively pursued federally right now, so do not have anybody at your organization interfere or provide false information when it comes to ICE. Be respectful with the ICE people and don't confront them, and reach out to legal counsel if you've got questions. We take questions on best practices in this area frequently.
Question number 6. My employee recently said some things online and I don't like, or excuse me, that I don't like. Can I fire him?
Well, it's frustrating to hear again, but the answer again is going to be it depends. This has been a pretty large hot button issue. We've gotten a lot of questions over the last couple weeks, I would say, on this specific topic related to current events, and employers are very concerned because of feedback that they are receiving from other employees, from outside clients, from news organizations, things like that. So this has been a big question that we've seen a lot of traction on lately. So some things to consider before you're looking to get rid of somebody or even just discipline somebody for their speech. You've got to look at what did the person say. A simple example would be somebody made a comment online, an employee that was direct discrimination or direct harassment. Say you've got an employee that posted something online negatively attacking the protected class status of another employee. Well, that's easy. If somebody goes online, they discriminate against or harass a coworker publicly and they're affiliated with your company, that person could likely be terminated. They make a direct threat to harm somebody, that person could likely be terminated. However, as we know, things are not always that clear cut. You also got to look at, okay, beyond the content of the statement, was it made during work hours? A lot of employers have policies on use of their time and don't allow employees during work hours necessarily to use social media. Somebody could be fired for violating rules, not necessarily the content of their speech, if they made company or made a statement during company work hours, or if they used company equipment and they were not supposed to. So that's a little bit more straightforward if somebody has broken a rule in terms of your anti-harassment or anti-discrimination policies. They made a statement during time when they were supposed to be working, violating a rule. They used your equipment, also violating a rule, to make say a discriminatory or retaliatory statement against somebody. Those are more straightforward. But what if you've got an employee that makes a politically themed post that other employees and even some clients don't like? And what if they do it on their own computer and it's outside of work time? So again, politically themed, not involving other employees, on their own computer outside of work time, that's a lot tougher of an issue to take on. So here are some items to consider when an employee's statement that they post online is not as clear cut as them just directly making a discriminatory statement against a coworker using company equipment on company time. So let's look at off-duty, no company equipment, politically themed. So what about the First Amendment? So when confronted by an employer about an online statement, a lot of employees will claim that their post is protected by the First Amendment and constitutes free speech. Well, the problem for the employee is that the First Amendment applies to government limitations on speech. The First Amendment does not apply to limitations imposed by policies of a private employer. So if you are not a government employer, your employee generally can't make a First Amendment defense claim against you because you're not the government limiting their speech. It's okay for an employer to have certain policies that limit employee speech in certain circumstances. The reasons that can back up an employer's limitations on speech that puts an employer in a better position are things like you want to maintain professionalism within the type of business that you offer. You've got customer expectations. You're looking at worker safety. Those are some reasons that an employer can use to back up, a private employer can use to back up a policy that they have regarding speech from employees. However, offsetting that can be a lawful off-duty conduct law that protects worker speech. So this would be a state law, and many states such as California, Colorado, New York have lawful off-duty conduct laws. In other words, if somebody does something that's off work time, they're not using company resources, they make a statement again, they make a post online that the employer doesn't like or a customer has complained about. In some states, if they didn't say something that was illegal, such as making a threat of direct violence against someone, that statement's going to be protected. Their off-duty conduct is not actionable by an employer. Some states even go a step further and they protect off-duty political activity. So think of Connecticut, Louisiana, Minnesota, South Carolina, Wyoming. Those states have laws that prohibit an employer from automatically disciplining or firing an employee for posting their personal views online while they're off work. That applies even if people don't like it. In states with lawful off-duty conduct laws or laws that protect off-duty political activity, an employer might be able to take an action only if they can show clear harm to the company. In other words, they'd have to be able to show that what the employee did with their political activity or with their off-duty conduct directly harmed the business. For example, a large client pulling their business where the company can say, hey, we lost this account. This account was $50,000 in revenue a year because this person posted this thing online. That is one possible time that an employer could take action, but again, it's very dependent on what your state law has to say. Another huge area to consider is the National Labor Relations Act. Again, we're going back to looking at the big federal laws that protect workers. That's another broad one. It covers employees' rights to organize, join unions, and collectively bargain for better wages and working conditions. But with the NLRA, with all of that information in place, keep in mind it's not just covering union and non-union workers, or excuse me, not just union workers, it covers non-union workplaces as well. And it also protects employee speech when it touches on conditions of employment. So if an employee says something that an employer doesn't like, but within that statement, they include information about work such as their wages, their working conditions, their job benefits, work schedules, how management treats employees, or they have legal concerns about harassment, discrimination, things like that. If that type of speech is included in a political post, then it makes it much more difficult for an employer to take an action against that employee because that speech could be protected under the National Labor Relations Act. So what do you do with these types of cases when you have something like this? Again, an employee has made a post online, the employer doesn't like it, or the employer hears from a client, they don't like it. What do you do? Well, you've got to be careful when trying to limit employee speech, even if you don't like the speech. Again, unless you're a government employer, the First Amendment won't apply. You've got to look at if you've got a state lawful off-duty conduct law and whether or not you could take action because that could protect the employee. You've got to look at, again, the NLRA and what did the statement say? Could it touch on the NLRA and thus be protected for the employee? And you want to consider the business impact on your company, not the political background of the person or the leanings of the message. Instead, you've got to look at the impact on the company, not what they said. You want to have neutral policies in place regarding employee speech. You've got to enforce them evenly. You've got to treat similarly situated employees. So even if you disagree with somebody's viewpoint or you agree with it, you've got to be careful and make sure that both times you're handling the situation in the same way. It's also important for employers to make sure their managers know about the state legal off-duty conduct laws if you operate in one of those states, the NLRA rules. Your manager should be familiar with anti-harassment, anti-discrimination, and anti-retaliation legal requirements so that employees aren't doing that. That could create liability for you. And also look at workplace safety. In other words, make sure your managers can see if somebody is making an actual threat of violence. And really, it does come down to, unless an employee's comment is just blatantly discriminatory, it's harassing, it's retaliatory, or it's making a threat of violence, unless it's one of those very clear-cut things from the start, don't rush into an adverse action. Talk to us if you've got a question.
Now for our last question of the day, are we required to pay severance to a departing employee?
You guys are sick of hearing the answer, it depends. So I will change that to it, maybe. Generally speaking, employees are not required to pay severance. You might be required to pay severance if there's an employment contract with the employee. So that means the employee is employed for a specific term under specific conditions. And sometimes if there is a contract in place, they may need to be paid severance if they're let go under certain circumstances. Another time that severance might be required is if you've got employees that are covered under a union collective bargaining agreement. Union employees that are subject to a CBA, when they are no longer working, may be eligible for severance payments if the CBA requires it. But what we see with most employees is at-will employment. At-will employment is the law of the land in 49 states. Montana is the only state that doesn't have at-will employment. That means that the person doesn't have a union collective bargaining agreement, doesn't have an employment contract, doesn't have a promise of employment for a specific period of time. So an at-will employee, they can quit at any time for any reason, or they can be fired at any time for any legal reason. So with at-will employment, severance is generally not required. An at-will employee, again, can be let go at any time for any legal reason. You can't fire them because for retaliatory purposes or just to discriminate against them, to harass them, that can happen. However, with at-will employees, paying severance can be useful as a legal strategy to help reduce risk for your business. If you're letting somebody go that's got a chip on their shoulder, they're mad at the company for some reason, paying severance could help lower the risk that they bring a claim against you if you pay that severance in connection with the employee who's leaving signing a separation and release of claims agreement. That type of document would pay the departing worker their severance, so that's got to be something they're not already entitled to. The severance has to be beyond their normal wages or a vacation payout, for example. But that extra payment of severance is in exchange for the employee signing off on the separation and release of claims agreement where they are agreeing not to bring claims against you. So is severance required? It might be if you've got an employment contract or a union CBA in play, or it could be a good idea if somebody's leaving and you want to help reduce risk of claims from someone. How can we help you? Ask us. We're here to respond to your employment law and HR questions. If you're not already subscribing to our weekly newsletter, please do so. We're going to provide updates on evolving employment law matters such as the topics we discussed today with our very frequently asked questions. And we also are going to advise you, if you're one of our clients, on the best way to handle your employee issues. And here's some information on how to reach out to us if you're interested in becoming a client.
Once again, thank you all for attending today. The questions that we provided today were examples of what our attorneys advise on our clients each day. And if you have any questions on the material covered, we ask that our clients open up a ticket in our Ask an Attorney portal. If you are not a client and would like more information about how we can help you, please email us at info@myHRcounsel.com. We hope to see you on another webinar in the future, and I hope you have a great rest of your day. Thanks again.
Thanks, everyone.